All right, welcome to our week 8 lecture recaps walkthrough. So this one's going to cover Unit 5 lectures 1 and 2. So both of the lectures you need for Unit 5 as you prepare for your first attempt. As always, highly encourage you to play these on your own ahead so that you can sort of test your own knowledge. And then come back here to the walkthrough portion to get the logic behind the answers and just sort of get a better understanding of those key concepts for each lecture. So let's go ahead and get started with Lecture 1's recap. So the first question is asking about those punishment philosophies that we see guiding our criminal justice system. And it's asking specifically about which one best fits a very controversial penalty in the death penalty. And as we talked about in lecture, the one that really fits best for the death penalty is incapacitation. And this might be a little bit counterintuitive, given that we would think the death penalty would deter people from committing crime. But we know that the evidence suggests that it doesn't have a deterrent effect, and to give somebody a deterrent effect, you have to give the opportunity to reoffend, which the death penalty does not do. Retribution doesn't really fit very well either because of how infrequently the death penalty is applied and how limited the role that the victim plays, or the victim's family plays, in carrying out the death penalty. Question 2 is looking at those types of deterrence and specifically identifying the type of deterrence that occurs when someone observes someone else being punished, or what type of deterrence can happen from that. And if you're observing somebody else and that has an impact on you, you're seeing an example of general deterrence. Specific deterrence happens when you punish one person and they learn from that punishment. General, on the other hand, is talking about punishing one person and having society or anyone who is able to witness it learn from that punishment. The last question for our first lecture deals with the insanity defense. And the question is asking about who determines whether a defendant is insane. Is it mental health professional, judge, prosecution, or jury? And as we've said in the lecture, insanity is a legal term, not a mental health term. And the only people responsible for defining that are the jury, or members of the jury. Mental health professionals can't pronounce you insane, the judge can't pronounce you insane, nor can the prosecution advocate. A jury has to find you insane because our system operates under the assumption of sanity, meaning until you prove us otherwise, we deem you sane and capable of understanding punishment. And so that's it for our Lecture 1 recap. Big keys here are understanding those different punishment philosophies, understanding the purpose, the idea behind them, going in depth into the different types of each of those punishment philosophies, and then understanding that insanity defense are really big things from this lecture to pay attention to. All right, so moving now on to our Lecture 2 recap. So the first question has to do with that fair sentence and how we get it within our system. And one of those things is having a fair and impartial judge. The question here is asking, how do we get judges selected, and specifically to the state system? Well, for the state system, we know that judges get elected. The federal system is a bit different in that a president will nominate a judge, and then the judges will go through an approval process through the Senate, by which point they become appointed, and the only way to remove them is through impeachment. The state system's a bit different in that judges are generally elected officials, and so they have to run for re-election as well. What's interesting about sort of the state system is that research tends to find judges rule differently in years that lead up to an election than they do after winning an election. They tend to be more harsh leading up to an election than following winning an election. Next question is dealing, again, with that sort of components of a fair sentence, and the last component is the pre-sentence investigator. And it's specifically asking about what percent of cases do judges accept the recommended sentence that the pre-sentence investigator provides. And what's alarming, or I guess shocking, is the fact that in most cases, in 90% of cases, judges accept the recommendations of the pre-sentence investigator, making it very important that the pre-sentence investigator is writing their report as unbiased as possible and as fair as possible. Next question deals with those sentencing models, and it's asking which one involved the strict application of full sentences. And as you recall from lecture, the only one of these options that really talks about the strict application of full sentences is mandatory sentencing. This really comes about of this fear that judges were being too lenient and we needed to control their discretion, so legislators would essentially write the punishment into law. And it becomes sort of this focus on the strict application of full sentences. The final question deals with the death penalty, and specifically looking for us to remember the Supreme Court cases that impacted the death penalty. And this one's asking which one reinstated the death penalty. And from lecture, you'll know that Furman versus Georgia struck it down, and then Gregg versus Georgia is the case that reinstates it. Part of what Gregg versus Georgia did was it established that you need to have a bifurcated process, where there's two parts, basically. That's what bifurcated means in this case. One part, you determine guilt. Are they guilty of murder? And in the second part, you determine whether or not they should be given the death penalty. So you split the process into two, determining guilt in one and then determine punishment in another trial. As I said, Furman versus Georgia strike down the death penalty and puts a moratorium on it for a time being because it was seemingly being applied arbitrarily, meaning that it was sort of at random who was getting the death penalty or not, aside from two common features, those being socioeconomic status and race. Wilkerson versus Utah, as we talked about, is key to the death penalty, is that it is the first case to establish the constitutionality of the death penalty and that it doesn't violate any of the constitutional amendments. All right, so that's it for this walkthrough from both lectures of Unit 5. You should have everything you need to prepare and study for your Unit 5 mastery quizzes.